in the matter of O'Brien versus Ministry of Justice.
Lord Reid will explain the judgment of the court.
This appeal is concerned with discrimination against part-time workers. Employers are prevented from treating part-time workers less favourably than full-time workers under an EU directive which came into force on the 1st of April 2000. Mr. O'Brien worked part-time as a judge between 1978 and 2005. At that time, UK law entitled full-time judges to a pension based on their final year's salary and their number of years' service. But it made no pension provision for part-time judges such as Mr. O'Brien. There is no doubt that he is entitled to a pension in accordance with the EU directive. The question is whether the year's service, which should be counted in calculating his pension entitlement, are only the years after the directive came into force, that's to say, the 5 years between 2000 and 2005 when he retired, or include the whole of his service, a period of 27 years. This is a question which affects many other people besides Mr. O'Brien. Under EU law, a new rule of law cannot apply to legal situations which have become definitive, as the European Court of Justice says, prior to the date when the new rule came into force. But it can apply to the future effects of a situation which arose under the old law. So the European Court of Justice has held that periods of employment completed before the directive came into force should be taken into account in calculating whether an employee's length of service qualifies them for a pension at all. His entitlement to a pension did not become definitive at the time of his employment, but was a future effect of that employment. In this case, Mr. O'Brien argues that under this line of reasoning, periods of employment before the directive entered into force must be taken into account not only in relation to qualification for a pension, but also in relation to the quantification of the pension, where its quantification is based on the employee's length of service. However, in cases concerned with the requirement for equal treatment of men and women in relation to occupational pensions, under a different EU provision, the European Court has treated occupational pensions as a deferred form of pay, the entitlement to which accrues continuously over the employee's period of service. In this case, the Ministry of Justice argues that following those cases, a worker's entitlement to an occupational pension is definitively fixed at the time of the work for which it constitutes deferred pay. On that basis, it's argued that Mr. O'Brien's non-entitlement to pension in respect of his first 22 years of service was definitively established at the time when he did that work before the directive entered into force. The majority of the Supreme Court is inclined to think that Mr. O'Brien is right. That's to say that the directive applies whenever the pension falls due for payment after the directive has entered into force, and insofar as part of the period of service took place before the directive entered into force, the directive applies to the future effects of that situation. However, the European Court has not yet considered the argument that if, following its case law concerned with the equal treatment of men and women, an occupational pension is treated as deferred pay, the right to which is acquired at the time of the work to which the pay relates, then it follows that the directive cannot alter the fact that Mr. O'Brien did not acquire any right to a pension in respect of his years of service before the directive came into force. Although the majority of the court are inclined to think that the cases concerned with the equal treatment of men and women can be explained as dealing with a particular problem which does not arise in the present context, the correct approach does not appear to the Supreme Court to be completely clear. In those circumstances, the Supreme Court is required by statute to obtain clarification of the EU law from the European Court itself. Therefore, this Court has decided that it must refer the question to the European Court.